Hearing in the appeal, Steele and another, and NRAM Plc.
Yes.
My ladies, my lords, maybe if at 1 minute past 5 on the 22nd of March 2007, Jane Steele had been asked the question, she might have been able to explain why the language she used in the email she sent to a commercial lender on behalf of her commercial client bore little relation to the arrangement that they had themselves reached, when over 7 years later she was asked to explain. She was unable to do so at the proof before the Lord Ordinary. She had no memory, and beyond a few isolated pieces of correspondence, she had no file. She offered an explanation, but it was, as the Lord Ordinary said, speculation as to why she did it. But it was offered as an explanation, not as an excuse. And it's never been suggested that in the missing file or the lost memory there's any answer to the charge of negligence. She could not have known the chain of events that her mistake would cause, and on that I do not speculate, because the Lord Ordinary found that a solicitor in Miss Steele's position would not have foreseen that Mr. Clark, the head of the loan review team, on receipt of the email, would simply send it on without taking the prudent step of opening the file and checking or seeking clarification from her. And she would not have foreseen that, my ladies, my lords, because this is not how commercial lenders acting prudently behave. At least that is how the Lord Ordinary saw matters, and the question for today is whether that was indeed the end of the matter. Now, moving on towards my submissions then, my ladies, my lords, as Lord Hoffman noted in the Grosjean case, before asking what the appellate scrutiny is in any given case, you have to first of all ask, well, what sort of questions was the Lord Ordinary, what the trial judge required to address first of all? The first question he had to address was to ask himself, well, what is the legal test here, and what questions arise in relation to that? And on that matter, the level of scrutiny for appellate interference is not in doubt. It's a question of correctness. And the first chapter of my submissions will indeed be about whether the Lord Ordinary was correct in his assessment of the law and the questions that he derived from it.
Yes, Mr. Duncan, we have obviously talked about this, and we are far more interested in issue 1 than we are in issue 2.
I'm grateful for that.
Issue 1 being the substance of the matter.
Indeed, indeed. Well, chapter 2, my lady, was going to deal with issue 2, and was to look at the way in which the Lord Ordinary approached the findings in fact and the threshold of scrutiny that was applied by the appellate court. And chapter 3 is in relation to really the response to what I say about that, which is my learned friend's position and the reliance on 2 authorities which appear to articulate a different level of scrutiny. So against that background, moving then to chapter 1, the legal question in the case. Now, the Lord Ordinary considered each of the 3 available legal tests in this area: assumption of responsibility, the threefold test, and also incrementalism. And he determined that whichever of these you approach this case through, you have to ask 2 questions. And those questions are these: whether it was reasonable in the circumstances for the pursuers to rely upon the misstatements without checking them. And secondly, whether Miss Steele ought to have foreseen this. Now, in so proceeding, the Lord Ordinary articulated what he took to be the essence of the pursuer's case. And we see that referred to in paragraph 3 of his opinion. I don't think we need to turn it up. And also we see Lord Brodie setting out the pursuer's pleadings in relation to that. And at no point in this case, my ladies, my lords, has the pursuer ever suggested that those 2 questions did not have to be asked. And at no point has the pursuer ever suggested that by failing on those 2 questions could the pursuer nevertheless succeed in this case. And the question is whether, in the way that the majority in the inner house approached this, whether they've actually circumvented those 2 questions. Now, as far as Lady Smith's criticism of the Lord Ordinary on this matter, as I read what she says, paragraph 54 of her opinion, and again, I don't turn that up unless the court wishes to go to it. The criticism seems to be that the Lord Ordinary failed to follow certain legal signposts. And insofar as there's explanation of that, I think we see that in paragraphs 43, 45, and perhaps most specifically in paragraph 47. And locating her analysis in observations made by Lord Bingham in the Customs and Excise case, Her Ladyship says of the assumption of responsibility test, it may be appropriate sometimes simply to ask the question whether responsibility has been assumed, and that could obviate further inquiry into those further could and should questions. In other words, the reasonable reliance question and the foreseeable reliance question. Now, what I want to say in relation to that, my ladies and my lords, that if that is how Lady Smith's observations are to be construed, and if that is where she indicates that the Lord Ordinary has fallen into error, in my respectful submission, it is Her Ladyship who has fallen into error on this. And I want to really do three things in relation to that. And as might become a repeated motif in everything I say, and perhaps my learned friend says, I'm conscious about trying to avoid reinventing the wheel in all of this. But I want to do three things. And the first thing is just to say something about what we mean when we talk of assumption of responsibility, just simply what does the term mean? The second thing is I want to look at the development of that concept in cases involving negligent misstatement over the last 100 years or so. And I'm going to make that a fairly whistle-stop tour, if I can. And finally, I'm going to look at maybe 2 or 3 cases where we actually see the individual questions that arise in a negligent misstatement case being applied and articulated. As to what it means then, the cases that the court has before it are replete with references to labels and to slogans being used to describe the various tests in this area, and that is true of assumption of responsibility also to an extent. The term is used in at least 4 ways, it seems to me. First of all, it is used as a descriptive term, or it has been used as a descriptive term, to describe the conclusion reached by the law that a duty of care falls to be imposed. Now, I'm not going to turn up the authorities, but if the court wishes to see examples of that, one can go to Lord Slynn and Lord Clyde in the Phelps case, and that would be respectively at pages 1018 and 1034 of the electronic bundle. Or we could go to what Lord Griffiths said in the case of Smith against Bush, and that would be at page 1238. The second way in which sometimes we see the courts using this term assumption of responsibility is where it's been used as a tool to fill a legal lacuna, and classically White and Jones would be the example of that. The third way in which it is used, and which brings us to this case, is it is sometimes the name given to the test, and sometimes, perhaps to make things more challenging still, sometimes it's described as a step within the test. But it's the name given to the test in those cases where we're concerned with loss arising from reliance on negligent misstatements. And the fourth way in which I've seen, or I'm able to divine its use, is that at least since the case of Henderson against Merit Syndicates, where the reliance is on a negligent service, it's appropriate to use the terminology there too. Now, so that sets the scene to some extent. I say we're in the third of those categories, a reliance on a negligent misstatement case. And that is an area, my ladies, my lords, where the long-standing exhortation from the courts to look for lower level questions has been followed, and where we have worked out we have available to us worked out solutions and questions in this area. That takes me really to the second stage of what I want to say in this chapter, and it's to think about the way that the law has developed in this area. Now, to go back to something I said a moment ago about reinventing the wheel, I have almost literally ringing in my head the observations of Lord Steyn and Williams against natural life, where he says the sole purpose of the citation of precedent is identification of legal principle, and where the legal principle is clear, hence, one might think, less citation of authority. And I look at the volumes that we have before the court, and I wonder about that. But
well, comparatively modest compared with many of the cases that we get.
I accept that. I was thinking it relative to whether or not there's certainty or uncertainty in the law in this area, and I say there's certainty. Because, my ladies, my lords, if we were to go back all the way to Lord Ashburton's case, Naughton, in 1914, and I'm not asking the court to turn it up, but it's tab 20, and it's page 936 of the bundle, we see that the key question in a misstatement case is about establishing the existence of a relationship in which it can be said that responsibility for reliability of information has been assumed by the provider. And we can see, particularly if the court were in due course to look at what Lord Shaw says at page 976, we can see that that relationship arises where the other person is entitled to rely on the information. Passing on 50 years to Headley-Burn, 1964, we see that indeed Lord Shaw's observations and others in Naughton are relied upon by the court. And we see that Lord Reid, Lord Morris and Lord Hodson, in speaking of assumption of responsibility, also speak about reasonable reliance. Lord Reid says that this relationship of proximity arising from an assumption of responsibility arises where it's plain that the party seeking the information was trusting the other and where it was reasonable for him to do so. And that's at page 759 of the electronic bundle. We see Lords Morris and Hodson saying similar things, respectively, at pages 776 and 787.
So what was your page reference to Lord Reid?
It is page
759.
I'm grateful I've lost
759.
I'm grateful I've lost my place.
No, it's just in case I want to check it later.
I'm grateful, my lady. I pass on a little further in time still to the case of Smith against Eric Bush, the two cases involving two separate valuations, two separate plaintiffs. Interestingly, the second group of plaintiffs represented by Mr. Coleman, QC, who would then be the judge at first instance in the Customs and Excise case, and I'll come back to that in a minute. But the central point to take in relation to that case, and it's at tab, I don't go to it, it's at tab 28. And the central point in that case was that, again, it was the overwhelming probability of reliance, to use the language of Lord Griffiths, at 1241. The overwhelming probability of reliance that allowed the court to say the necessary proximity is here, and the responsibility was assumed by the valuers. And then we moved from a case that was advised in April 1989 into the following year, February 1990, when Caparo was advised. And again, at the risk of taking this far too quickly, again, I don't propose to turn this up. We will see in due course what Lord Bridge and what Lord Oliver said when I look at another case. But I'm thinking in particular about Lord Bridge's narrative of the development of the law, and it's at tab 60 when the court comes to look at it. Sorry, tab 6, I should say. And his discussion of the narrative of the law, which begins at page 569. And he sets out the way that the approach of the court has waxed and waned, starting from the traditional case-by-case or category-by-category approach to things, moving up from what Lord Atkins said to look for a broader principled approach, eventually getting to what might be thought to be the high point of that in Anne's, the retreat from Anne's, led by Lord Keith, back to a traditional approach. And what he says that in relation to that is that in this sort of case, a case to do with reliance on an advisor from misstatement, he says that to determine the essential characteristics for establishing a delictual duty not to cause economic harm through misstatement, one must go to the cases relevant to that particular, as he puts it, relatively narrow corner of the field. So descend from the high-level threefold principle down to the questions that really matter. And that's what he says. It's at page 572 of the electronic bundle. And he derives that guidance from Hedley Byrne, from Lord Justice Denning's dissent in Candler and Crane, and from what Mr. Justice Chitty had said in the case of Cann. And he says that the essential characteristics in this sort of case are that the advisor or the provider of the information would anticipate reliance by the recipient, and that the recipient would reasonably suppose that he was entitled, he or she was entitled to rely on the statement. And that's at electronic pages 573 to 574. And he goes on in due course to talk about these being essential ingredients of proximity. Now, Lord Oliver is in somewhat similar terms. The pattern of the narrative is the same from the case by case to the broad principle back to the more incremental approach to things. And he deduces principles from Hedley Byrne 2, and we see these at electronic bundle 591. There is a difference between what he says and what Lord Bridge says. He does not refer to the reasonableness of reliance. He talks about one of the criteria being whether, in line with what Lord Bridge says, whether the whether the provider of the information ought to have foreseen that it was likely to be acted upon without independent inquiry.
Mr. Duncan, to what extent are the concepts of reasonable reliance by the addressee and reasonable foreseeability by the speaker different?
I think that's a difficult question. I think that there are three possible answers at least. One, they're not, in the sense that it might be said that Lord Oliver's approach is essentially saying implicitly they're both in the mix. Secondly, one might approach it in the way that the Lord Ordinary did here, which is to say that there are two sides of one coin. Or thirdly, and we'll look at this case in a moment, we'll look at something that my Lord Hodge said, sitting in the outer house of the Court of Session, a case called Spooner, where you can actually see the connectedness of them all. And essentially what my Lord Hodge said was, one needs to foresee harm. To foresee harm, one needs to foresee reliance. To foresee reliance, one needs to be able to say that objectively there will be reliance, and there will be objectively reliance where it is reasonable. So I think they are separate questions. They both arise, as I see it, but in some cases, maybe perhaps in Hedley Byrne, where there was a request for the information, the question maybe doesn't arise particularly.
And it's perhaps useful to remember that in Hedley Byrne, the disclaimer was a complete answer. It rather emphasises that, as I'm looking at what Lord Reid says, that because of the disclaimer, he says the respondents never undertook any duty to exercise care.
Yes.
And in there, he must be thinking of a real, a genuine undertaking to be careful, an assumption in a real sense,
Yes.
rather than something which is a conclusory description of a situation where you can reasonably foresee reliance.
Indeed. Indeed. I would accept that, my lord, because we are, and it starts to take me more towards also what I'm going to say in relation to the appellate jurisdiction. In the same way that this court was looking at in the case of Royal Bank of Scotland against Carlisle, in this case, we're looking at the question of whether a legal obligation was entered into. It seems to me that the way my Lord Reid has put it is rather in line with that. But on the whistle-stop tour, we finally, or penultimately I should say, we come to the case of Williams against Natural Life Health Foods. Again, with apologies, I don't turn it up, tab 33. Lord Steyn, with whom Lords Gough, Hoffman, Clyde and Hutton agreed, said that in that particular negligent misstatement case, the test was whether the plaintiff could reasonably rely on the assumption of personal responsibility. So, thinking about what Lady Smith said, and thinking about that particular passage in Lord Bingham's judgment that she relies upon, that's the context in which Lord Bingham said assumption of responsibility may obviate further inquiry. He wasn't saying it's obviates further inquiry into the ingredients within the test. He was saying it obviates further inquiry into those other separate tests, the threefold test and incrementalism. Unless there be any doubt about that, the reference in the passage in Lord Bingham's judgment that she refers to makes it clear that, and it's at page 630 of that report, sorry, I should have said.
Could I just have the page reference to Lord Steyn's?
Yes, of course, I do apologise. It's page 1421.
1421. Thank you very much.
And the particular passage that Her Ladyship relies upon to direct her in this particular case is in the Customs and Excise Commissioner's case, which is at
4, I think, isn't it?
Indeed, my lord, and it's at tab 8. And maybe we should just turn this up. It's in the lengthy paragraph 4, and it's at the very end of that, and on page 630 of the electronic bundle.
Thank you.
Where, and this is why I say what I say about the context in which Lord Bingham makes this observation. He says, having referred to Headley Burn and also Mr. Justice Coleman, at paragraphs G, he says, I think it's correct to regard assumption of responsibility as a sufficient but not a necessary condition of liability. First test which answer positively may obviate the need for further inquiry. If answered negatively, further consideration is called for. Now, he's making those observations against the background of Headley Burn, etc., but also against the background of what Mr. Justice Coleman had said, who, as I mentioned earlier, had appeared for the Harrises in the Smith case. And what he said, and I regret the court does not have this before it, but what he said at paragraph 33 of his judgment is that the key on assumption of responsibility is whether there was justifiable reliance, which is absolutely in line with what Lord Shaw had said. And if the court wishes the citation for that, it is 2004, One Weekly Law Reports at 2027.
Sorry,
2027.
Thank you.
And it's at paragraph 33. So that, and I think maybe, so I've given two pieces of context to that observation of Lord Bingham. One, that he locates it, having discussed Headley Burn, etc. Two, the reference to Mr. Justice Coleman. But perhaps the third is this, that clearly Customs and Excise Commissioners is a novel or borderline case where they were having to decide matters at a high level. It's not a negligent misstatement case on any view. So I say the law is very straightforward here, and it's settled. I also say that once a judge has considered and applied these lower level questions to do with reliance, there really is no room for a further inquiry into the threefold test. And that is axiomatic, because if the judge has decided that there's no assumption of responsibility, then there is also no relationship of proximity, and nor is the threshold for foreseeability reached. And as regards the incremental test, well, the answer to that is that by applying these lower level principles and questions, the judge has applied the incremental test. He has gone to that, in this case, he's gone to that corner of the field concerned with cases of this type. Now,
but how helpful is it to say that the law should develop incrementally? What use is that comment to us?
Well, again, that's a difficult question, but I find it difficult to know what that means. And I think when one goes through the authorities, for all that we have seen, at least since Caparo, direction to look for lower level principles and perhaps to incrementalism, we also see other observations saying that one has to look to the higher level principles in a novel case. And it must be that one needs to do both. It seems to me in a novel case, and this is not a novel case, nor a borderline case. So the final aspect of what I wanted to say on the law was really just to think about 3 examples of how these questions have been applied by lower courts to appellate courts and one judge at first instance. And the first of these is the case of James McNaughton against Hicks Anderson, which is at tab 16, and it's at page 854. And it is another case involving reliance on statements made by accountants. And I just simply wanted to look at what Lord Justice Neal said about the tests in relation to reliance, foreseeability and reasonable reliance. And if we go to page 865, here we see that he sets out what Lord Oliver had said in Caparo. And I touched on this in my brief recitation earlier. So the 4 questions which Lord Oliver considered failed to be answered in a case to do with reliance on a statement. And I'd emphasise to this court number 3. And then over the page, we see that he also locates his analysis in what Lord Bridge said in Caparo. And again, I've already alluded to that. And in particular, I've placed emphasis on reference to reasonable reliance, the foot of that quote from Lord Bridge. And Lord Justice Neal then set out a number of questions that may arise from that framework. And I don't need to take time up with these other than just to notice them. I would notice, however, 2 of them in particular. The 5th of them, which is at page 867, where His Lordship refers to the precise state of knowledge of the advisor is one of the most important matters to examine. And to some extent, that's an answer to the criticism that was made at one stage, at least in this case, about the Lord Ordinary's reliance on the subjective views of Miss Steele at the time. And if we go back to think about Smith against Bush, that was a case which was decided because of what the valuers subjectively knew, at least in the Smith case. And then notice also what His Lordship says about reliance at the foot of page 867. Paragraph H, one should consider, therefore, whether and to what extent the advisee was entitled to rely on the statement to take this action that he did take. So entitlement, the language used by Lord Shaw and the language used in the pleadings in this case. It is also necessary to consider whether he did in fact rely on the statement, whether he did use or should have used his own judgment, whether he did seek or should have sought independent advice. In business transactions conducted at arm's length, it may sometimes be difficult for an advisee to prove that he was entitled to act on a statement without taking independent advice, or to prove that the advisor knew actually or inferentially that he would act without taking such advice. And it seems to me that these observations and questions are absolutely opposite to the process of trying to construe whether a formal legal relationship has come into being. Now, this case is also of some interest in relation to the court's appellate jurisdiction in this area. And I won't take time up with this, but I would just notice that the court in this case felt able to intervene because at the time the judge at first instance had advised the case, Caparo was not available. So the judge had not had that guidance. And secondly, it is obvious from the discussion of Lord Justice Neal, just noticing, for example, at page 869, it is obvious that the judge had not made certain findings and had made errors in relation to at least one finding, looking at what's said, for example, paragraph D. And were the court to go back to look at the submissions that were made in this case on behalf of the advisors in the case, one can see that, in fact, it was being suggested there were quite a lot of matters in which no findings had been made. And that may well have been because of the absence of the Caparo guidance. Lord Justice Balcombe is to similar effect in all of this. Now, the second case I was going to look at, my ladies and my lords, was the case of BCCI against Price Waterhouse, which is at tab 3. And on this occasion, it's Sir Brian Neal who we are concerned with. And this is a case that's been cited on several occasions in this current case in each of the two lower courts in which it has visited.
Page.
And in particular, my lady, I want to, the report is at page 456, and I want to go to page 479.
Thank you.
And really just to do two things in relation to this. At page 479, I've just noticed at the end of the quotation, at paragraph C, the end of a quotation, a well-known quotation from Lord Hoffman and Stoven. The trend of authorities being to discourage the assumption that anyone who suffers loss is prima facie entitled to compensation. And I just wonder whether, looking at the way that Lady Smith began her discussion, perhaps began from the wrong starting point. And I'm thinking too of what Lord Justice Steyn said in his judgment in White and Jones in the appeal court, where he said something to a similar effect, that loss, lies where it falls. But against that background, I look also, my ladies and my lords, to the particular questions which Sir Brian Neal derives, both from the threefold test and from the assumption of responsibility test, which, again, this is at paragraph D, which rather chimes with my assessment that it doesn't matter where you start from, it's ensuring that you get to the right lower level questions.
Do you have in mind I don't know if this is what you're referring to, but there's a passage in Lady Smith's judgment at paragraph 38 where she says that as a generality, the
Yes.
law imposes a duty not to cause foreseeable harm.
Yes.
Where that harm is economic loss, the court has to decide whether, as a matter of policy, a duty of care should be held to have existed.
Yes. I mean, I do think there's a flavour between paragraphs 38 and paragraphs 42 of language, and indeed in the discussion generally about the law, of language that is not a million miles away from the principles that were discussed by Lord Wilberforce in ANS.
Yes.
Indeed. So the questions articulated by Sir Brian Neal in BCCI, and I just notice, I think it's really just A, C and D of these, my ladies, my lords, the inquiry should be into the precise relationship between the advisor and advisee. This may be a general relationship or a special relationship which has come into existence for the purpose of a particular transaction. And I think in this particular case in my submission, that's perhaps an observation of some importance in which the pursuer relies upon a very specific relationship created by a single email, and in relation to which the Lord Ordinary had no explanation from the solicitor's side at all, and a file on the lender's side. Perhaps taking me into my submissions about appellate jurisdiction, it seems to me that all the more underlines the respect that's required for what he did. But I also, my ladies, my lords, rely on paragraph C, and in particular the very foot of page 479, where his lordship talks about the degree of reliance which the advisor intended, or should reasonably have anticipated, would be placed on its accuracy by the advisee, and the reliance, in fact, placed on it, and at D, the presence or absence of other advisors on whom the advisee would or could rely. This factor is analogous to the likelihood of intermediate examination in a product liability case, which is an issue we touch on in our case. And he says, if I might go on slightly, I just noticed what he says also at the foot of page 481. In cases where the parties are dealing at arm's length, the court is likely to be slow to extend the orbit of the duty of care to include persons other than the immediate client. There is a barrier which has to be overcome, and this barrier will be strengthened or even duplicated if a third party is in receipt of independent advice.
Of course, Lady Smith, at paragraph 46, accepted or said she considered there was merit in a submission that this was not an arm's length transaction. It was in the interests of both the bank and the borrower to ensure that the sale was completed.
Indeed.
Yes, but it clearly was an arm's length transaction, because the negotiation which had taken place 6 months before required the borrower to agree how much it would accept in order to discharge the security. Indeed. The most that can be said, it might be thought, is that it was the implementation of an arm's length transaction which had been agreed, which didn't involve a conflict of interest.
Indeed, I can see that, but her ladyship, I think at one stage describes there being a commonality of interest between the parties, but I think the key point for my part on that is that that was something that the Lord Ordinary determined, and on the facts determined that there was no such commonality of interest or identity of interest.
Mm-hmm. Well, in one sense, you can always say that two sides to a bargain have got a commonality of interest. That's why they made the bargain. They both think it's going to be to their benefit. But that doesn't mean to say that it's not an arm's length transaction.
Well, indeed.
In both making and implementing the bargain.
Indeed, I think that's correct, my lady. And in thinking in particular about the two criteria which Lady Smith relies upon, she says it was in the interest of both of them to get the deal done, and secondly, they would both benefit economically well, as your ladyship in the chair says. In what deal would that not be the case? What arm's length deal would that not be the case? So I have so far looked at at the slightly lower level, the further provision of detailed questions and detailed guidance. I want to finally go at the lowest level to an explanation from my Lord Hodge in a case where we really see why it is we ask these questions, it seems to me. And it's the case of United Central Bakeries against Spooner. It's at tab 31 and the electronic number is 1306. And the case is, on its facts, it's of little assistance in the sense that, as his lordship says, it was actually a case that was concerned with physical injury arising from misstatement, and it was a legal debate. There was no evidence at this point. But I would just like to go to what my Lord Hodge said about the tests that arise where one's concerned with reliance on a negligent misrepresentation. And the discussion begins at paragraph 35, at page 1320 of the electronic bundle. Because his lordship, having obviously recognised that the dichotomy between physical and economic loss, says one mustn't overstate it, and indeed, in cases involving negligent misrepresentation, there are questions common to each of those two types of case, physical, economic loss, which fall to be asked. And he sets those out, beginning at paragraph 37. Paragraph 37, he emphasises that context is important and goes back, touches on the familiar discussion in Headley Burn about the difference between an informal and a formal statement. Paragraph 38, he then deals with the question of foreseeability, and it's this point in particular that, in my respectful submission, explains why it is we need to ask these questions in this context. A's ability to foresee that the harm may result from a careless statement will depend on his awareness that B is likely to act. B's reliance is relevant to causation, but to act or refrain from acting and to suffer the injury or damage to his property, But the objective likelihood of that reliance is relevant to the existence of ambit of A's duty of care. It affects both proximity and reasonable foresight. In my view, the reasonableness of B's reliance is a factor which would be taken into consideration in assessing that objective likelihood. So one derives from the reasonableness of the reliance, the foreseeability of the reliance, and from that, the foreseeability of the harm. There is, in short, no route round these questions, in my respectful submission. And it is interesting that my Lord Hodge concludes what he says there by saying these questions are mixed questions of fact and law, which is really taking me towards my second and my third chapters. But I just conclude this first chapter then by saying this, that the questions for the Lord Ordinary were, in the pursuer's case, and has been explained in all of the key cases in this area, to determine whether reliance was foreseeable and whether it was reasonable. It would seem to me that Lady Smith has not approached matters in this way. And that being the case, in my respectful submission, it is not the Lord Ordinary who has fallen into error here, it is the majority in the extra division of the Inner House.
Do we see, if you're right in that regard, do we see that error encapsulated in the first three sentences of paragraph 47 of Lady Smith's judgment?
Yes. That's how I see it, my Lord.
Yes.
What she seems to be saying is that based on that observation of Lord Bingham, the Lord Ordinary did not need to go on and further ask the could and should questions. And the could and should questions are the reliance questions. And it seems to me that some corroboration of that, just picking up on my Lord Hodge's question, perhaps some corroboration of that is to be found also in what she says in paragraph 50 about foreseeability, where she seems to be applying a test of foreseeability that would not be the test in a negligent misrepresentation case, thinking in particular about what my Lord Hodge said in the Spooner case. So, I'm not sure there's a great deal further I could say on issue 1 beyond that which I've said already. And as I said a moment ago, in my respectful submission, it is not the Lord Ordinary who has fallen into error here.
That seems to be correct. You needn't say a lot about issue 2.
Well,
We feel that we have said rather a lot about
well,
the
again,
relationship between
again, the words of Lord
appellate
Steyn.
courts and trial judges. So we are more interested in the substance of the matter.
Well, I mean,
But say whatever you feel like saying.
well, against that background, I will tread warily and say as little as I need to, perhaps. In my submission, the appellate threshold is clear here. It is set out in many cases. It applies to each of the questions that the Lord Ordinary had to ask, whether it's inferences, primary facts, or his evaluation. Maybe the two things I would say are these, just two things. It is sometimes necessary to distinguish between the separate legal questions or questions that arise in a case. I'm thinking, for example, about the analysis of your ladyship in the chair in the case of B, and indeed my Lord Wilson and indeed my Lady Black in the Court of Appeal, I think in that case also, about the different stages of primary fact finding, inferences, evaluation. But the law is clear, and the same test discussed in Royal Bank of Scotland against Carlisle or in Henderson against Foxworth applies. And so that's all I say really in relation to what I say the law is, namely that, well, it's really two things. I think it's to be recalled that when we go back to what Lord Thankerton said in Thomas against Thomas, in this case it's important not to overlook the start of what he said. The start of what he said is that where an appellate court is considering on the printed evidence to come to a different view. And then I jump much further forward in time to think about something that my Lord Hodge said in the Beacon Insurance case. It's not just looking at the printed evidence. The appellate court's got to find the error in what the judge at first instance did. Well, this appeal before the Inner House was not conducted on the basis of the printed evidence. Neither side made submissions or put in arguments based on the written evidence, and it's not clear what bits of the written evidence that the appellate court looked at. And secondly, Ladysmith identifies no errors, it seems to me, in the true sense of that word. So one is in the position of it being necessary for the pursuer in this case to have shown to the Inner House that in the absence of some other identifiable error, that Lord Docherty had gone plainly wrong or had come to findings that he could not reasonably come to. That, to me, to my mind, to my submission, is the law. And I think, as I understand it, what's said against me, and thinking in particular about what your ladyship in the chair said a moment ago about the law being settled, it does seem to be being suggested here that the law is not settled, or at least that there's a contrary view. And the respondent in this appeal rely on three authorities, I think, in relation to that. They rely upon what the Inner House has recently said in a case called AW against Greater Glasgow Health Board, which is at tab 2, and I don't turn that up. But in that discussion, in that opinion of the court, which was a case to do with an appeal after a lengthy proof on an issue of clinical negligence, the court appears to have indicated that the rule in Thomas against Thomas, and in Clark, and in Henderson, does not apply to secondary findings in fact. And the paragraphs in question are 41 to 42, 44, 49 and 51. And sorry, the electronic page for that report is 272. And that, in my respectful submission, that's simply incorrect. The second authority that's relied upon here is a series of 3 SLT articles, which the court may have seen at the very end of the court's bundle. The author is not identified, but is understood to be a serving member of the judiciary in Scotland. And this is at...
Bashful one.
I'm sorry?
A rather bashful one.
Well, indeed. On inquiry, we were told that that is apparently the convention, or at least it's the convention now, I think, is maybe what we were really being told. But in any event, tabs 38 to 40, I take many issues with that, and I absolutely accept that my place for doing that is at my desk and writing an article rather than using this court for that. But there is one particular matter which I do need to address, and that is essentially the author says that the recent Scottish cases have introduced considerable uncertainty and controversy into the law. I was aware of neither of those things, but that might just be me. That's at page 1609. More particularly, it is said that this court did not follow the usual approach in the case of Royal Bank of Scotland against Carlisle and applied a different threshold of scrutiny, and in particular did not notice that on issues of law, it's all about correctness. So even if it's a mixed question of fact and law, the question for the appellate court is purely one of correctness. And criticism is made in particular of the fact that the question in Carlisle, which was to do with whether an intention to enter a legal obligation had arisen during a phone call. Criticism is made that that was characterised as a question of fact. Now that causes me some particular nervousness because that was a concession made by the respondent in the case, and I wrote the respondent's case. But what we said was that it was a question of fact, primary and secondary fact, connected to and not capable of being separated from questions of law, the application of vague legal standards. For example, what would the reasonable offeree have thought? And in that regard, the discussion and the approach is exactly the same as we see in the case of Howson and Nicolaisen, where they speak about these matters too, and thinking about what the reasonable municipality would have thought. So without taking time up on this, I say that discussion is incorrect. And the final thing, the court might have noticed in the bundle that there are a number of authorities which might be described as undergraduate classics: Hughes against Lord Advocate, Muir against Glasgow Corporation, and Bolton and Stone. The reason that those are in the bundle is because the author in the Scots Law Times article, and my learned friends in their case, say that Hughes is an example of the court, of an appellate court, reaching in and disturbing findings of foreseeability. Now, Hughes is at tab 15 on page 833 of the electronic bundle, and at the risk of being a broken record, again, I don't ask the court to turn it up. But I would just ask the court to notice what Lord Guest said. There were 2 issues of foreseeability in that case at appellate level. And the court will no doubt recall the case. This is the case about the 2 boys who ended up, one of whom ended up suffering a serious injury when he wandered into a covered manhole. It was an explosion, and he was seriously burned. And there were 2 issues in the appellate court that were challenged. And one was whether the Lord Ordinary was right to say that the presence of those boys was foreseeable. And the second question was whether the test for foreseeability, as regards what then happened, required the defenders to foresee the exact mechanism of the accident and the severity of the injury to the little boy. The second of those, as is clear from the court's discussion, was a question of law. The first of those was, as Lord Guest says, a question for the Lord Ordinary, and he did not interfere with it. And we see the same approach taken in the case of Muir against Glasgow Corporation. And I would just notice in particular what Lords Macmillan and Lord Thankerton say, respectively, at pages 926 and 924. The question of what Mrs. Anderson, who was the lady who was involved in that case, the question of what she should have foreseen was a jury question. And one sees the same approach in Bolton and Stone, which is at tab 5, page 538. And I'm thinking in particular of what Lords Porter and Normand say.
In this case, Lady Smith sets out in some detail all the mistakes that she thinks Lord Ordinary made in his approach to the evidence in paragraph 49, and we can make up our minds what we make of those. That he didn't have any expert evidence about how prudent banks behave, that there was nothing in the evidence to show that the solicitor need not foresee that there was a risk of reliance. And she goes back to the issues of commonality of interest and so forth. And she also places some emphasis on Ms. Steele's going beyond her client's instructions.
Indeed.
Yeah. So, I mean, she gives us quite a lot of reasons why she feels Lord Ordinary erred in his assessment of the evidence, and we can make what we can of it.
Well, indeed, and just to pick up on one of those, where she says there was nothing in the evidence in the Lord Ordinary's findings to indicate to her that she should not foresee the appreciable risk. As we say in our case, there was a finding by the Lord Ordinary that based on previous transactions, Miss Steele expected them to check. That was evidence in the case that was accepted by the Lord Ordinary. And the Lord Ordinary rejected the contra proposition that those prior transactions supported this engendering of trust, which she refers to both in paragraphs 49 and 45. There was no evidence, no finding in relation to that. And so I would maybe characterise what Lady Smith does there slightly differently from the way my Lord Reid has done. I don't see these as criticisms of the Lord Ordinary. I see these as different findings. And I think that is an important difference. I think as regards the ways in which we say Lady Smith transgressed the appellate rules, I'm not sure there's more I can say that's not already set out in my case. And against that background and on those submissions, I would respectfully invite the court to allow the appeal.
Thank you, Mr. Duncan. Thank you very much. Mr. Patterson.
Thank you, my lady. My ladies, my lords, I have nothing to add.
Mr. Clancy.
Perhaps if I can begin by summarising, and I emphasise summarising our position on the question of whether or not this court should find fault in the way that the Inner House intervened with the Lord Ordinary's decision. We say that the key issue in this case, which is whether a duty of care existed, is properly characterised as one of applying the law to the facts. There are what might reasonably be described as different strands of authority as to how that issue should be approached. One of those strands can be found in the case known as the Maragitha Maria, a fishing boat case. It's cited by the appellants in their case, and it's at tab 29. If I can take the quote there, please, briefly. This is page 1253.
You will, of course, appreciate, Mr. Clancy, there is quite a well-developed body of law on liability for economic loss resulting from negligent misstatements in general, and indeed more particularly relating to solicitors.
Yes.
And so we have a body of established principles, and really it might be thought that it's that body of law we should be looking at and deciding whether applying the principles to this case, whether liability should be imposed. I mean, I'm not going to stop, obviously, try to stop you looking at this, but just looking at the head note, it seems to be rather remote from what we're dealing with.
The feature that I'm focusing on, my Lord, is that it does self-consciously raise a question of applying the law to the facts. The issue in the case is whether the deceased fishermen were co-adventurers on the one hand, or whether they were employees of the vessel owners on the other. That is, in my submission, an issue of applying the law to the facts, which is broadly comparable to a range of other cases where this kind of issue has been described. The reason why it respectfully seems necessary for me to go here is that where I take issue with my learned friend is where he suggests that the test is the same for the review of primary facts, for the review of inferences, and for the review of so-called evaluation issues. And I take him to mean by that, for example, whether in a given set of facts negligence has or has not occurred. So that I need to answer that. I say that whatever may be the case, the test is not the same for primary facts, inferences, and questions of applying the law to the facts. And that's why I'm going here to show briefly how the third category of those has been dealt with in some appeals. So those are the, that was the basic question of applying the law to the facts that arose in that case. And if we could go to the judgment, please, of, well, actually it's helpful to look at the head note because it summarises the position. Perhaps just paragraph 4 onto page 1254, where there was no written contract between the parties, nor indeed any evidence as to the words used by the parties to create their contract, the basis on which they actually conducted their relationship may frequently involve issues of primary fact. And the first stage of the inquiry, as to whether there was a contract of service, must almost always be to identify all the relevant incidents of the relationship. The second stage involved deciding whether those facts taken together lead to the conclusion that there was a contract of service. So if we go from there to the judgment of Mr. Justice Neuberger as he then was, which is on the passage I want to look at is at page 13, it's paragraph 60. Which is on page 1265. So in the second column there, he says, having determined the factual incidents of the relationship, the first instance tribunal has to proceed to the second stage, which involves deciding whether all those facts taken together lead to the conclusion that there was a contract of service, whether one characterises that conclusion as an inference, as a conclusion of law, or which I doubt as a finding of secondary fact. It seems to me that the essential point is it would be a conclusion arrived at by a proper evaluation of the effect of the various factual incidents of the relationship. In principle, it is plainly easier for an appellate court to be persuaded to interfere with the conclusion reached by the tribunal at this second stage than it is in relation to the decision at the first stage. That is because in relation to the second stage, an appellate court is not being asked to interfere with the tribunal's primary findings of fact. And then paragraph 61, nonetheless, where there is a challenge to a first instance tribunal's conclusion at the second stage, namely whether or not there is a contract of service, I do not consider that an appellate court faces a black or white choice, as it would on a point of law, such as an issue of contractual or statutory interpretation, between holding that the tribunal was right or wrong. The first instance decision may fall in a grey area, a sort of margin of appreciation, where an appellate court may indeed, should conclude that the tribunal reached a conclusion which which it was entitled to reach and with which the appellate court should not interfere. After all, the exercise in which the tribunal is engaged in a case such as this is weighing up various factors, some of which point one way and some of which point the other, and reaching a conclusion as to the side on which the balance ultimately comes down. In my judgment, in such a case, an appellate court should not interfere unless the first instance tribunal has misdirected itself on the law, either expressly or impliedly, has taken into account a factor which it ought not to have taken into account, and has failed to take into account a factor which it ought to have taken into account, or has reached a conclusion which, in light of the primary facts, it could not properly have reached. Now, that formulation of the test bears very strong resemblance to the formulation given by my Lord Reid in the Henderson v. Foxworth case.
About I hadn't read this before, but it's a fairly familiar way of putting things.
And in my submission, that emphasises the difference between a review of a question of primary fact on the one hand and a review of an inference, a review of a question of applying the law to the facts on the other. Now, if I can move on to a second point, as my learned friend has pointed out, we have adopted an argument in our case which postulates what might be described as a more liberal or a more expansive approach to the question of review of the application of the law to the facts. And we adopted the reasoning in the article, the SLT article, which founds on the traditional Scottish cases and which says that historically appellate courts have been perfectly happy to revisit for themselves the question of negligence on a basic set of facts. Lords, we acknowledge that that approach, if it is correct, is subject to a qualification. That's a qualification which has been made in other cases, and the important qualification is that whilst the starting point is that the appellate court can re-evaluate the issue, they must attach due weight to the decision that the first instance judge took on the point, and the amount of weight that they need to attach will be very dependent on the circumstances. At one end of the spectrum, you have essentially uncontroversial findings in fact, which are in relatively short compass, and indeed where documentary evidence looms large in the primary facts, then it is much easier for the appellate court to intervene. And of course, at the other end of the spectrum, in a complex case with very nuanced questions of fact, the judge will have enjoyed the advantage of not only being immersed in the case, but of having picked up subtleties and nuances along the way, which would inform a sensible decision which he or she alone could make. Now, in my submission, there is ample authority for that qualified approach to the more liberal, as I've called it, ground of intervention. If we go back to the case which is frequently cited in this context, Ben Max versus Austin Motor Company, is mentioned in several of the dicta which are featured in the cases before this court. Ben Max was a case where the question of applying the law to the facts was whether the patent in suit involved an inventive step. Of course, there were legal rules which governed the concept of an inventive step. They had to be applied to the facts of that case. And Viscount Simmons in a speech with which certainly Lord Reid and others concurred, drew a sharp distinction about drawing inferences on the one hand and primary facts on the other.
And do we have that case?
I regret to say we don't, my lady. I can give the court. Fortunately, the speeches are very brief. Viscount Simmons is at page 373 of the report, and I'll come back with.
But we don't have it.
We don't have it, lady.
It's not common for counsel to cite passages from cases which we do not have before us.
I think, with respect, my learned friend has been allowed one indulgence in that regard, my lady. I would pray in aid, or I would rather seek the court's indulgence in relation to this one matter.
Well, at the very least, what you can do is give us the law report's reference, which I believe Mr. Duncan did give us.
It's 1955 appeal cases, page 370.
I'm grateful to my Lord Reid. It is worth mentioning in passing that it does feature or is mentioned in the Maragitha Maria case in the paragraph after the one which I read to the court, paragraph 63.
Before we leave that case, can you just help me by tying down what's said here? I'm assuming that you think that supports you, the passage that you read us from paragraph 61.
I think that's what, my lady?
The passage from paragraph 61 of the Maragitha case, yes. I'm assuming that you think that's supporting your position, helping you. The passages that I'm interested in is, an appellate court should not interfere unless the first instance tribunal, and then the fairly conventional list of things which have to have gone wrong before they can interfere. Now, you consider that that passage supports you in your position in this case?
In making a distinction between reviewing primary facts on the one hand and reviewing inferences on the other.
Right. So they're talking about inferences here, and what are the factors that are not taken into account by the Lord Ordinary here, or the misdirection of law?
Yes. I'm going to come on to them if I may, my lady, but there are three features of this case which I say are the decisive ones, both in relation to the appellate jurisdiction and the merits of the case. The first is, in my submission, it's a misdirection to say that the test is one of reasonable reliance, taking account of the advisee checking the accuracy of the statement. There is a principle in my submission which is along the lines that where a negligent misstatement is made, it is no answer from the advisor to say, but the advisee could have checked for him or herself. So that, in my submission, is an error of law, and if I may, I'll come on to develop that.
And it was more proper to ask about assumption of responsibility.
Yes, indeed, my lady. Well, or that if one is looking at the question of reasonable reliance within the context of the assumption of responsibility test, I say that you leave that out as a matter of law. The fact that it could have readily been checked.
Yes.
The second point is the fact that in this case, the first defender was acting not just out with her instructions, but in a sense contrary to her instructions. The arrangement which had been entered into 6 months previously between her client and the respondents was the client was going to repay some of the balance of the loan outstanding, and in exchange was going to be given a deed of restriction to enable him to sell one of the properties that were covered by the security. And that was the deal, so to speak. And whether it was a binding contract or whether it was simply an arrangement is nothing to the point.
So that's a factor which ought to have been taken into account and wasn't.
Well, the factor that ought to have been taken into account is that 6 months later, entirely of her own initiative and for reasons which have never been explained, the first offender writes to the respondent saying the whole loan is going to be repaid. I have a figure for that. Here are the discharges which you need to execute in order to release the security.
But she's not defending the case on the footing that she was an agent acting within the scope of her authority. So this is not a red herring.
Well, with respect, Lord, no, because when we look at the Gran Gelato case, we see that there is authority for the fact that the question of whether a solicitor steps outside their instructions is a highly relevant consideration to the existence or not of executive care. Now, if I can complete the point, at least in summary form, if you analyse the situation properly, when she did what she did, not only was she not acting in accordance with her instructions, but in a sense, she was acting in conflict of her instructions, because the client had an ongoing business relationship with the Northern Rock. He had reached an arrangement which was to their mutual satisfaction, namely, they would get part of the loan paid back and they would release part of the property from the securities. And what she did, or what she put in chain, was a series of events which resulted in neither her client or the Northern Rock getting what they wanted. Now, a point which is, in my respectful suspicion, sometimes lost sight of in this case is that we're not just dealing here with advice or information that was given by the first offender to the respondents. She drafted, prepared, and sent discharges for execution by them. So that is conduct going beyond the kind of advice or misstatement which features in many of the assumption of responsibility cases. Indeed, virtually all of the assumption of responsibility cases that my learner friend visited in his survey. So there are two features which really set our case apart in that regard. One is, contrary to heavily buying in other cases, there is no question of acting out with instructions. And secondly, there is the element of conduct. Now,
you've been a little bit deflected from the proper role of an appellate court,
yes,
into the substance of
yes,
the matter, into issue 1, which obviously is of paramount concern in this case. Do you wish to stay with that, or do you wish just to give us the page references to the passages in Ben Max on which you rely, or have you slid away from that?
Lady, I was asked by Lady Black about...
Yes, it's
You
my
were,
fault.
you answered her question, that's fine.
I haven't quite finished
I just want to know where we now are.
You still need to give us the third feature
indeed, my
in
lord.
this
Yes.
excursus and then return. Yes.
Third feature, in response to Lady Black's question...
I should stress I was only asking for headlines. I wasn't
Yes,
asking
all right.
for the case on the...
Well, the third one is a point that's been touched upon discussion with already this morning. It was whether the Lord Ordinary was correct to say that there was no community of interest, or whether, on the other hand, the Inner House were correct to say that there was a community of interest. And I'll come back to that.
Right, that's very helpful, thank you.
So, to go back to where I was in relation to this question of the correct test for the appellate jurisdiction, I did mention Ben Max. Ben Max, the legal question was, or the mixed fact and law question was, whether the patent involved an inventive step. Viscount Simmons, in his short speech, draws the clear distinction between primary facts on the one hand and matters of inference on the other.
And at what page do we find that?
At page 373. Now, again, labels are a slight issue here, because one can take inference to mean a secondary fact based upon the premise of primary findings in fact, and it's often used in that sense. But it is clear from what Viscount Simmons says that he is using inference also to cover questions like whether somebody has been negligent. The way that he distinguishes the two matters is to say primary facts are a question of perception, inferences are a question of evaluation, and he gives, as a specific example of an evaluation and inference, whether somebody has, in a given set of facts, been negligent.
You'll know that this passage was the subject of comment in Biogen, and Lord Brodie, I think, referred to what was said by the House of Lords in that case.
Lord, I was going to go on to acknowledge that there has been some development in what the appeal courts have said about this, but to complete what Viscount Simmons had to say, basically he said that for an inference, including one of these issues of evaluation, the appeal court is entitled to form an independent opinion subject to the weight which should be given to the views of the judge at first instance. Now, the difference between that and Lord Neuberger's formulation in the fishing boat case may be, in practice, very little. The only conceptual difference is that in the shipping boat case test, the court is not allowed to interfere unless it can find a certain fault, whereas in the Ben-Max formulation, the general proposition is that the appeal court is entitled to interfere, subject to giving due weight to the first instance judge.
Which might suggest they are somewhat different tests.
Conceptually, they're different, but when one goes on to look, my Lord, at what has subsequently been said about the importance of attaching weight to what the trial judge thought, they get closer and closer. I come back to a point which I've already made. In a case where the facts are relatively straightforward and short compass, and indeed heavily reliant on the documents, it should be much easier in my submission for an appeal court to say we can interfere because there is nothing in relation to an advantage enjoyed by the trial judge generally or in relation to specific issues which puts him in a better position to judge this than we are.
Mr. Clancy, can we be a little bit more specific as to what we're talking about when we consider whether the inner house had the right to interfere with conclusions? Correct me if I'm wrong, but we are talking about the conclusions in paragraph 78 of the Lord Ordinary's judgment, namely that it was not reasonable for a bank to rely on the misstatement without checking its accuracy, and that Ms. Steele would not foresee that it would do so without checking. When we say, well, was the inner house entitled to depart from that? Did the inner house depart from that, or did the inner house say, all that's irrelevant?
The inner house, in my submission, if you read the judgment, the majority of the inner house said they addressed the issue head on, and they said that the Lord Ordinary was wrong about that, and that the correct conclusion lay in the opposite direction. You'll find...
Didn't Lady Smith say, well, we don't get on to, one should ask whether it was foreseeable that they would act on this without checking.
First sentence of paragraph 47.
Yes, paragraph 47 at page 105.
I mean, that is I would suggest, a critical paragraph.
Lords and ladies, look at this perhaps a little more closely then. 47 begins, in these circumstances, the Lord Ordinary required to ask whether this was one of those cases where the law attributes assumption of responsibility to the solicitor, and in so doing provides a complete answer to the duty of care question, obviating the need for further inquiry, including inquiry as to whether or not NRAM could or should have checked their file. So what Ladyship seems to be doing there is to deal directly with what was the essential finding of the Lord Ordinary, namely that the respondents should have checked their file. That was obvious to anybody. That would have been obvious to any solicitor in the position of the first offender, and therefore the duty of care doesn't arise. And in particular, it's not necessary then to go on and look at it beyond that. But one then has to read what comes next. And if we go to 48, Her Ladyship says, if, however, the threefold test was a relevant consideration, I note it was not disputed that the requisite proximity existed. Accordingly, following the guidance in Customs and Excise case, the questions, one, whether a reasonable solicitor would in all the circumstances have foreseen that if you sent the email of 26th March with its attachments, there was an appreciable risk that NRAM would suffer loss, and two, whether in all the circumstances it would be fair, just and reasonable to impose the duty of care. Now, in relation to the first enumerated question there, she is going on effectively to discuss the question which the Lord Ordinary answered against us. We say that her formulation is correct, whether a reasonable solicitor would, in all the circumstances, have foreseen that if you sent the email of 22nd March with its attachments, there was an appreciable risk that NRAM would suffer loss. Not that they would inevitably act without checking, a likelihood of them simply complying with the request. If that was reasonably foreseeable in all the circumstances, that would be sufficient. And then in paragraphs 49 to 50, to answer Lord Wilson's question directly, this is where the majority of the Inner House go on to tackle head-on the questions which Lord Ordinary answered in favour of the appellants. And what we say, quite simply, is that in the context of jurisdiction, the exercise that was conducted in paragraphs 49 and 50 was an entirely legitimate one. It was open to the Inner House to revisit these questions, and they answered them in the correct way.
Am I not right in thinking that Lady Smith dealt first of all with assumption of responsibility and then dealt with what she calls the threefold test? And in paragraph 47, she finds that there was an assumption of responsibility, or at any rate, that the law attributes an assumption of responsibility to Ms. Steele. And so by the end of 47, she's decided that your clients win. They win because there was an assumption of responsibility, and therefore a duty of care.
Lord, that may depend on how the court went on to answer the three-stage test, because if their analysis in applying the threefold test had been different, then we may have had a different formulation at the beginning of 48. The way it's put there, if, however, the threefold test was a relevant consideration, and so on,
yes,
may well have had a different formulation if, for some reason, the Inner House had taken the view that the threefold test produced a different result.
Yeah. It seems to be a sort of fallback. I mean, 47 says that the Lord Ordinary required to ask whether this is one of those cases where the law attributes assumption of responsibility, and in doing so provides a complete answer to the duty of care question. And she answers that yes. And then it's really if, just in case the threefold test is relevant, then she then goes on to deal with the Lord Ordinary's approach to that and identifies what she thinks are a number of errors in paragraph 49, and indeed 50. Dealing there with, I think, the issue of, yes, because in 48 she identifies the three elements of this threefold test. Proximity is not in dispute. Secondly, reasonable foreseeability. And thirdly, fair, just, and reasonable. And 49 and 50 and 51 are all, I think, dealing with the reasonable foreseeability issue. And then the Lord Ordinary at 52, she notes he didn't consider the question of fairness, justice, and reasonableness.
Lords, while we're looking, and I don't propose to read read through all these passages, but perhaps for use later on in my submissions when I come back to some of the main issues on the merits, can I direct you to paragraph 52 of majority opinion on page 106. And the context is a final discussion about the fair, just and reasonable aspect of the threefold test. But if we look at the last 5 lines, and then beginning at the end of the 5th last line, where she says, "Indeed, it might be thought invidious to suggest that the solicitor can abrogate responsibility for a serious error because the recipients of her communication might have checked rather than relying on what she, as a hitherto trustworthy professional communicating them as a solicitor, told them, particularly when she herself took no action to correct the error when on receipt of the signed discharges it was within her power to do so." Now, our position, rightly or wrongly, is that we are on strong ground in relation to the considerations which are set out there by the Inner House. It is inverting the concepts of fair, just and reasonable to some extent to say that a solicitor without instructions of her own volition who puts into chain these events by sending these discharges.
Well, she had instructions. She simply made a mistake in carrying out her instructions.
Yes, I mean, she was clearly purporting to carry out her instructions. She got it wrong. The solicitors had to send a request for a letter of non-crystallization of the floating charge. That was within her remit from the client. Where she went wrong was she mischaracterized the agreement between the client and the bank and therefore sent an inappropriate document to give effect to that arrangement. I don't think it helps to talk of going on a frolic of her own or anything like that. I mean, that is I think, a fair description of what happened. Do you disagree with that?
I respectfully disagree with that, my lords.
Why?
The question of whether a solicitor is acting in accordance with their instructions or whether they've simply made a mistake in implementing their instructions is a spectrum question. But
it affects the liability of a solicitor's client. But why should it affect the liability of a solicitor?
The starting point is the arrangement between her client and the bank. Insofar as we know, and I think this was established by the evidence, her instructions were give effect to this arrangement which involves a partial repayment and a restriction of the loan. If she then does something which is so radically different from that without explanation by sending discharges and representing for some inexplicable reason that the whole loan is going to be repaid, then in my submission she crosses the border between making a mistake in implementing instructions on the one hand into territory where she is simply acting contrary to her instructions on the other. Now that, in my submission, is an important feature of this case. When we get to Grandulato...
Well, can I ask one question? Was there any evidence that she knew at the time that she was consciously acting contrary to her instructions?
She had no memory whatsoever of... She had not only no explanation, but no memory for what happened. What I'm inviting the court to do is to accept the starting point being that her instructions were from a client who had a friendly relationship with the bank, a deed of restriction in exchange for a partial repayment.
Yes. Yes.
There,
she spoke of having the sum that was needed for repayment. Now, that's something which, in the normal course of event, would come from the bank.
yes.
Yes, because
Or indeed, it would. The source would initially be the bank. Whether it would be passed from the bank to the client to the solicitor is
yes. So it's pretty clear that she misunderstood the transaction that she was writing about at the time she wrote that email.
I'm asking the court to assess this objectively. The question of whether she made a mistake or what the explanation is will never be known, my lord. I'm saying, objectively speaking, and I hope when I get there I will find some support for this position in granulato. I say that despite the fact that, as has been pointed out by the court this morning, the context is an arm's length transaction between two principals, it is possible in the context of implementing that transaction as it was put this morning, to find a common position between parties. And in this case, it was the mutual expectation that part of the loan would be paid and only part of the security would be discharged.
So where are we actually in the argument at the moment? You've been taken a bit off your course. And
I need to complete, if I may, the little more that I have to say about the appellate jurisdiction and then come back and just deal in a little more detail with some of my submissions on the merits, if I may. I was suggesting that we've had two strands of authority in relation to appealing questions of
two strands of authority in relation to inferences, inferences having a wide variety of meanings.
The third strand, if I can put it that way, are the dicta of Lord Hoffman, which feature in Lord Brodie's opinion here. The cases are Graham Building Services. Perhaps the best way to deal with this is to look, if we may, briefly at Lord Brodie's minority opinion. It's paragraph 75. This is page 114. I don't propose to read all this, but the general thrust of the passage is looking at the question of the respect which has to be afforded to the opinion of the judge at first instance. And if I can ask you to take it up towards the foot of the page, about 3/4 of the way down, where Lord Brodie says, Lord Justice Hoffman, as he then was to similar effect in Ray v. Gray and Building Services, a director disqualification case. The judge is deciding a question of mixed fact and law in that he is applying the standard laid down by the court's conduct appropriate to a person fit to be a director to the facts of the case. It's in principle no different from the decision as to whether someone has been negligent or whether a patented invention was obvious, see Ben Max. On the other hand, the standard applied by the law in different contexts vary a great deal in principle, and generally speaking, the vaguer the standard and the greater the number of factors which the court has to weigh up in deciding whether or not the standards have been met, the more reluctant an appellate court will be to interfere with the trial judge's decision. And then he goes on to cite Lord Bridge in the George Mitchell case. It would not be accurate to describe such a decision as an exercise of discretion, but such a decision under any of the provisions referred to will have this in common with the exercise of a discretion, that in having regard to the various matters to which Section 11 of the Act directs attention, the court must entertain a whole range of considerations, put them in the scales on one side or the other, and decide at the end of the day on which side the balance comes down. There will sometimes be room for a legitimate difference of judicial opinion as to what the answer should be, where it will be impossible to say that one view is demonstrably wrong and the other demonstrably right. It must follow, in my view, that when asked to review such a decision on appeal, the appellate court should treat the original decision with the utmost respect and refrain from interference with it unless satisfied that it proceeded upon some erroneous principle or it was plainly and obviously wrong. Now, we would like to take the court to a further passage in the judgment of Lord Justice Hoffman in that case, because he does expand to some extent on the passage which Lord Brodie has quoted. Can I take the court to tab 26, which is in volume 2?
Hey.
Page the report, my lady, begins at 1178. The passage which I've just read is at page 1192.
And the one you want us to look at is
on that page. If we go to 1192, in the top third of the page is the quotation from Lord Bridge in the George Mitchell case, which I've just read, and which is where Lord Brodie stops. And if we read on, Lord Hoffman did go on to say, similar comments were made in this court in Ray Coventry, deceased, about a decision as to whether a testator had made reasonable financial provision for a defendant for the purposes of the Inheritance Provision for Family Independence Act, or Justice Buckley described such a decision as a value judgment which should not be disturbed unless the judge has made an error of principle. These cases are at one end of a spectrum, and decisions such as whether a motorist has driven with due care and attention are probably somewhere near the other end. Where lies the decision that a director's conduct fell below the appropriate standard? In my view, nearer to the negligence end than that represented by Finney, Locke or Coventry. If Mr. Bannister were right in saying that the judge was involved in a general inquiry about the defendant's current fitness to be a director, then I think he would probably also be right about the approach to an appeal from such a decision. Mr. Bannister was arguing for a very restricted approach because he was defending somebody who had been found at first instance not to merit disqualification. But if I could go back to Lord Hoffman, but since I think that the true question is a much narrower one, namely whether specific conduct measures up to a standard of probity and competence fixed by the court, I agree with the way in which the matter was put in Ray Hitco 2000 Limited, after citing a passage in Ray Sevenoaks Stationers Retail Limited, in which Lord Justice Dillon referred to the question of unfitness as a jury question. The Deputy Judge went on, plainly the appellate court would be very slow indeed to disturb such a conclusion as to fitness or unfitness. In many, perhaps most cases, the conclusion will have been so very much assisted and influenced by the oral evidence and demeanour of the director and other witnesses that the appellate court would be in nowhere near as good a position to form a judgment as to fitness or unfitness than was the trial judge. But there may be cases where there is little or no dispute as to the primary facts, and the appellate court is in as good a position as the trial judge to form a judgment as to fitness. In such cases, the appellate court should not shrink from its responsibility to do so, and if satisfied that the trial judge was wrong to say so. So, we acknowledge, as I have done, that the concept of due deference to the trial judge has developed since Ben Max. It has been elaborated in the ways that we see described by Lord Hoffman, but we're still left with, in my submission, the important point that the appellate court should not shrink from its responsibility to interfere, satisfied that the trial judge is wrong in a case where the facts are straightforward. My learned friend mentioned the approach of the Inner House in the recent case of AW, the clinical negligence case, which is tab 2. In my submission, I'm not going to take up time with this, but in my submission, the approach they have adopted is what I've described as the slightly more liberal or expansive option. The starting point is a willingness to interfere subject to due deference to real issues where the trial judge has enjoyed an advantage. And that's the sum and substance of what the Inner House have said in that case. Lords, can I consciously step now away from the jurisdiction point and come to complete my submissions on the merits proper? first point I want to make is simply a reiteration in this context of the issue about how much difference do we have to give to the Lord Ordinary here. The reason that is important is that in his minority opinion, Lord Brodie expressed some sympathy for the respondent's position on the merits, going as far as to say if it had been down to me at first instance, I might well have found for them. But the key reason that he gave for concluding that the Lord Ordinary's decision should not be interfered with was essentially deference to him and his advantage as the finder of fact. And our point, quite simply, is that he is wrong because there is little or no importance to be attached to that so-called advantage in this case. There is nothing of the penumbra of imprecision as to emphasis and nuance which Lord Hoffman refers to in the Biogen case in the passage which is cited by Lord Brodie at paragraph 75. I move on now then to the three factors which I attempted to summarise earlier in my submission. And the first of those is the prominence which the Lord Ordinary gave to the respondent's failure to check the accuracy of the misstatements made by the first offender. Read as a whole in my submission, that was the dominant consideration as far as the Lord Ordinary was concerned. It's at paragraph 78 of his opinion. Up to that point, he's identified certain factors which he describes as being neutral or in some sense favourable to the respondent's position. We get to 78 and he takes the plunge and says, this is where the respondents fail and this is why. It was unreasonable of them not to check, and a solicitor in the position of the first offender could not reasonably have foreseen that they would not have checked. Pardon me. We say that that involves a misdirection in law and or taking account of an irrelevant consideration. We say that there is a legal principle of general application which comes into play here, and it's set out again in a passage in Lord Brodie's minority opinion. So if I can go, please, to page 115, which is Lord Brodie's opinion, and I'm looking at paragraph 76. Page 115. I return then to the interlinked should this court entertain and should this court sustain questions which I posed earlier. I do not demur from the observation of your ladyship in the chair that factors to which he refers weigh in favour of attributing an assumption of responsibility to Ms. Steele. In paragraph 17 of their note of arguments, the pursuers cite two judicial dicta which I would see as having particular rhetorical force. They are taken from a passage in the judgment of Sir David Nichols in Grandulato, which is referred to by the Lord Ordinary at paragraph 81 of his opinion. The first is, quote, no man can complain that another has too implicitly relied on the truth of what he himself has stated. The second is, no one is entitled to make a statement which on the face of it conveys a false impression and then excuse himself on the ground that the person to whom he made it had available the means of correction. And then Lord Brodie goes on, as I indicated, to say that had he been sitting in the person's seat, he might have been persuaded that the first offender should be regarded as having assumed legal responsibility. So those are
the dicta, they're made in a different context, aren't they?
Yeah. They're made in, I'm coming to that, Lord, they're made in the context of, well, in two senses they're in a different context, because in the cases which they're referred to, the issue under discussion is contributory negligence, but they are said to be general principles in my submission.
Well, also different in that the first one's a case of fraud, fraudulent misrepresentation inducing a contract, and the second's a case of breach of fiduciary duty.
Lord, can we perhaps look first of all at the granulato discussion of this? Granulato is at tab 12, which is in volume 1 of the authorities. I don't propose to go into the facts of this. It is an assumption of responsibility type case involving information passed by a solicitor on one side of a transaction to the solicitor and the principal on the other side. If we could go to page 733. Context is a discussion about contributory negligence. The Court of Appeal held that there was no duty of care owed, but went on to consider the question of contributory negligence. If we take it up at page 733 at letter C, where the Vice-Chancellor says, "In my view, it would not be just or equitable to make any reduction in Granulato's damages. The essential feature of the present case is that Granulato's claim, both at common law and under the Act of 1967, is based on misrepresentation. Richcliffe intended, or is to be taken to have intended, that Granulato should act in reliance on the accuracy of the answers provided by Gershon Young. Granulato did so act. In those circumstances, it would need to be a very special case before carelessness by Granulato, the representee, would make it just and equitable to reduce the damages payable to compensate Granulato for loss suffered by it in consequence of doing the very thing which, in making the representation Richcliffe intended should happen, viz. That Granulato should rely on the representation. The principal carelessness is not making other inquiries provides no answer to a claim when the plaintiff has done that which the representer intended he should do." And he goes on, "This is a well-established principle when misrepresentation, whether innocent or fraudulent, is being relied on as a ground for seeking rescission of the ensuing contract."
Now, when the Vice-Chancellor says intended that which the representor intended he should do, that's in the context of between C and D, that Richcliffe intended, or is to be taken to have intended, that Granulato should act in reliance on the accuracy of the answers.
In my submission, Lord, reliance should, as a matter of principle, leave out the question of whether it could be checked. For the first offender to say in this case, they did exactly what I wanted to do. They obligingly, if somewhat naively, went along with what I asked them to do without checking. In my respectful submission, the principle that we're looking at here is sufficiently general application that it can apply to the situation which your Lordship's just described.
Well, in the Lord Ordinary's, on his findings, Ms. Steele intended that the bank, well, he doesn't find this, but I imagine she must have intended that they would do as she had asked, but on his findings, she didn't intend that they would rely on what she was telling them.
The Lord Ordinary, in my submission, has incorporated into his test the important qualification in relation to reliance without checking. And my proposition is that by virtue of this principle, that is the wrong legal approach, that you apply your mind to the question of reliance generally, but you do not give the person who makes the negligent misstatement the protection of saying that the test is whether or not reliance the test is reliance without checking. Well, I may say that I'm also going to defend Lady Smith's analysis that the Lord Ordinary has got that wrong, even if that is the correct test. But in my submission, it is... In the passage I'm looking at here in Granulato, I emphasise the words from D to E. In principle, carelessness in not making other inquiries provides no answer to a claim when the plaintiff has done that which the representative intended he should do. That's a well-established principle when misrepresentation, whether innocent or fraudulent, is being relied on. Negligence simply lies in the spectrum between fraud and innocent misrepresentation.
Well, what his lordship says is it's a well-established principle when misrepresentation is being relied on as a ground for seeking rescission of the ensuing contract.
Yes. In my submission, the Vice-Chancellor is not seeking to draw a distinction between cases where the remedy sought is rescission on the one hand and where damages are sought on the other. And I think I'm right in saying, I'm going to come on to this, I think I'm right in saying Nocton is not a rescission case. We can all read for ourselves the quotes that, or the passages which the Vice-Chancellor cites, and he completes his analysis on the next page at 734. In my view, the like approach is applicable when considering what is Granulato's share in the responsibility for the damage flowing from the misrepresentation. It may be surprising that Mackenzie Mills did not advise their clients against proceeding without seeking the head leases containing the covenants their clients were undertaking to perform, but that has no relevance to the loss suffered by Granulato in consequence of its reliance on the representation in answer. Now, in my submission, that's the approach which the Lord Ordinary should have taken in the question of primary liability in our case, either in the context of the assumption of responsibility test or in the application of the threefold test.
Is there a difference between the purchasers here in Granulato? They didn't have the head leases. Yeah, the question arose, should they have asked for them? But that's the situation there. In our situation, the bank had absolutely within its file, accessible within seconds, the answer to this. Is there a difference?
The way that the principle is being applied here, my Lord, I answer that in the negative. It doesn't turn on how easy it would be to check.
Well, we'll have to make up our minds as to whether Sir Donald Nichols was intending this to be a principle of general application or was actually considering the issue in front of him.
The cases which he cites are the Reynolds v. Spry case, which, as my Lord Reid has pointed out, was a fraud case. Interestingly, in that case, the principle was said to apply even though the fraudster, who was Captain Spry, had recommended to the plaintiff that he take advice. And the principle is also said to apply in circumstances where the guilty party puts into the hands of the other the means of discovering the truth. Now that's very close in my submission to the point that my Lord Wilson makes about the fact that the Northern Rock had the information at hand. And then the other case is Nocton, which is tab 20. It was a claim for indemnity for payment of money rather than rescission on the grounds of fraud and breach of fiduciary duty.
I think you can say, in answer to Lord Reid's observation 5 minutes ago when he said, well, you've got to read Lord Dunedin's statement on 966 as being in the context of a fiduciary relationship between solicitor and client. You could have said to him, my lord, I wonder whether you would actually go to 966 and see that the statement is followed by Lord Dunedin's observation, but besides that, Nocton was in a fiduciary position. So you might have been able to say to Lord Reid, that statement does not depend on the fiduciary relationship.
Lord, I'm glad that he's heard that now, even though I didn't say it. I'm grateful to you for that. Lords, before I finally leave this point, can I say two other things? One is that in my submission, tackling this point head on, the Inner House's analysis is correct at 49 and 50, which is at page 105. If I may say also that that's patently in my submission not an area where the Lord Ordinary enjoyed any advantage.
Well, I wonder about that. I mean, if you look halfway down 49, there's a sentence which starts at the edge of the page. There was nothing in the evidence or the Lord Ordinary's findings to indicate to her at that time that she need not foresee that there was an appreciable risk of her email being relied on and acted on. That, after all, was precisely its purpose. But the Lord Ordinary, at paragraph 56 of his opinion, said that subject to one qualification, which was the fact that they didn't have solicitors, he accepted her evidence that in relation to the earlier transactions and the parts of Unit 1 transaction which he does recall, that she expected the pursuers to check matters before they complied with any request which she made. So is the Inner House right in its assertion in that sentence to which I read you?
In my submission, they are correct, my Lord, because it is an objective test. Our position in relation to that passage of evidence, which comes in the context of our having no recollection at all about the transaction, and not being able to reconstruct the circumstances from the documents, is there. But ultimately, the answer to that is, well, it's an objective test. So what she now says she thought at the time is not determinative of the matter.
But they weren't Lady Smith wasn't addressing an objective test in that sentence. There was nothing in the evidence to indicate to Miss Smith.
Well, in a sense, in my submission, Lady Smith is perhaps
Miss Steele
raising a point which needn't have arisen in support of the appellant's argument. We take our stand on the fact that this is an objective test.
Yeah, thank you.
The final issue in regard to this was put in sharp focus by my learned friend's submission this morning, because in the context of the assumption of a responsibility test, there is the dictum from Lord Oliver in Caparo where he builds without checking into the important element in relation to reasonableness or reasonable feasibility. And we have a series of responses that we would wish to make there. Lord Oliver is summarising the authorities through Headley Byrne up till then. As best we can tell, and we've looked carefully at this, the without checking formulation is exclusive to his analysis of the matter. It's not, for example, we think in what Lord Bridge had to say, and we should look at that if we may. was tab 6.
Yeah, it's just that
Yes. I'm reading from the very foot of page 573, letter H, where Lord Bridge says, the salient feature of all these cases is that the defendant giving advice or information was fully aware of the nature of the transaction which the plaintiff had in contemplation, knew that the advice or information would be communicated to him directly or indirectly, and knew it was very likely that the plaintiff would rely on that advice or information in deciding whether or not to engage in the transaction in contemplation. In these circumstances, the defendant could clearly be expected, subject always to the effect of any disclaimer of responsibility, specifically to anticipate that the plaintiff would rely on the advice or information given by the defendant for the very purpose for which he did, in the event, rely on it. So, reliance, yes, but without checking, not in that passage.
But a subjective awareness of the likelihood that the plaintiff would rely on the information. But you accept that there is that element in Lord Bridges' formulation?
I don't shy away from that, my Lord.
Yes.
We would also make the following points, if we may, that care has to be taken in relation to comparisons between our case and these Headley-Byrne type cases right through the line to Caparo. There is a significant difference between a case where what's under scrutiny is information or advice which crosses over from one side of a transaction to another, and the circumstances of our case. And I come back to factors I mentioned already, the absence of instructions, which is not a feature in any of these other cases. The fact that the negligence involved conduct, action in the provision of the discharges beyond simply making assertions of fact or opinion. And also, I'm coming back to I'm coming back to the question of a community of interest as opposed to being arm's length. Finally, Lords, in response to the Oliver point, this is an instance in my submission where, because of the particular factors in our case, it is conceivable that the court would be unable to find its way to holding reasonable reliance according to that test, but could nonetheless hold that there was the threefold test, and in particular the requirement of foresight in that was established. For that, I do rely on and support the Inner House's analysis from paragraphs 49 through to 51. Lords, can I move on, please, to the second principal feature of the case? I'll take this briefly because I think we've covered most of the ground already, which is the absence of instructions. I've asserted that this involves simply not a case of failing to follow instructions properly. It's something different entirely, and in a sense, it involves a conflict between what she did and what she was instructed to do. we say that that makes this a case where the first defender stepped outside her role as solicitor for the client and thereby accepted direct responsibility to the respondents. And if I can go back, please, to the Grandulato case for this, which is tab 12, volume 1. I'm looking at page 730, which is an earlier passage in the judgment of the Vice-Chancellor. The context here is discussion of what's described as a general rule that a solicitor on one side of the transaction does not normally owe a duty of care to the principal on the other side. And the general rule is acknowledged and is accepted by the respondents here. But if we take it up at page 730 at letter G, the Vice-Chancellor says, I must emphasise 2 points. First, there will be special cases where the general rule does not apply and a duty of care will be owed by a solicitor to a buyer. A good illustration is the New Zealand decision of Allied Finance v. Haddo. Their solicitors acting for a borrower certified to an intending mortgagee that specified documents had been duly executed and were fully binding on their client, and that there were no other charges on the boat which was the intended security. The solicitors were held to owe a duty of care to the lender in connection with the giving of that certificate. On any reasonable appraisal of that arrangement, the solicitors must be taken to assume personal responsibility to the mortgagee for the accuracy of the certificate. That is a case in which, to adapt the language used by Lord Donaldson in Al-Kandari, in the context of a solicitor acting in adversarial litigation, the solicitors had stepped outside their role as solicitors for their client and had accepted a direct responsibility to the lender. Now, before we leave that, if I can just emphasise what's said in the first sentence there, I must emphasise 2 points. First, there will be special cases where the general rule does not apply and a duty of care will be owed by solicitor to a buyer. So, the two aspects of that are that where the exception is established, the duty of care is said to arise.
But the example that's given, I don't know about New Zealand conveyancing practice, but it's a certificate given by a solicitor. It's a very specific action done by the solicitor themselves.
Yes. Well,
you couldn't get a much clearer assumption of responsibility, probably.
I would venture to suggest that the same could be said of the first offender here in sending discharges which were not something that were required by our own clients in the course of the transaction.
The fallacy seems to be that that we can all accept that if the solicitor is merely transmitting information provided by the client, then she does not assume personal responsibility for it. And the fallacious step is then to say that therefore, if she is not merely transmitting information given to her by the client, it follows that she is assuming personal responsibility for the accuracy of what she says.
I'm reminded by Leonard Jr. that we don't go as far as to say that night follows day, my lord. We say that that is, in a sense, the way we put it is a weighty factor more than rather than simply night follows day. Can I look briefly at how the Lord Ordinary has dealt with this. In the first place, at paragraph 65 of his opinion, this is page 133. It says, paragraph 65, Dean v. Allen and Watts, supra, is an example of an exceptional case where a duty of care was imposed. There, the unrepresented lender and the borrower had a common interest that the lender obtained a good security, and the first defendant, the borrower's solicitor, had assumed responsibility to the borrower and was acting on behalf of both borrower and lender to advance their common interest. The present case appears to me to involve a very different scenario. The misstatements in the email did not involve the advancement of the common interest of HCL and the pursuers at HCL's behest. In our submission, that is wrong. The common interest is there to be seen plainly in our submission in the present case. The common interest being, as I put it earlier, on the one hand, for the bank to get repayment of part of their loan whilst only releasing part of the security, and on the other hand, the freeing up of the proceeds of sale of the unit which was being released from the security. That, in the context of a transaction which admittedly, in the most general sense, is at arm's length. The important point is in our submission that when we look at Dean, as I'm about to do, the situation is exactly the same. The parties were on the opposite sides of a transaction in the general sense. These were loan transactions, and the lender was looking for security in respect of the loan, and the borrower was purporting to provide that security. The loan transaction was at arm's length, but there was a commonality of interest. So if I can take you to Dean, which is tab 10, beginning at page 687. And I regret that I do need to read the head note to make this point. The claimant agreed with Mr. Beasy and Mrs. Young, the borrowers, to make a consecutive series of 4 loans to them, each loan replacing its predecessor, and that the claimant, Mr. Dean, should have as security a charge on a leasehold flat of which Mr. and Mrs. Sharman were the registered proprietors. The charge was to involve the deposit by Mr. and Mrs. Sharman of the title documents to the flat, the deeds. The loans represented a very substantial investment so far as Mr. Dean was concerned. The borrowers instructed Mr. Dolan of the defendant's solicitors to advise and take the necessary steps to effect the transaction. The 4th loan was £50,000. Mr. Dolan advised the borrowers that a mere deposit of the deeds would be sufficient and effective, and was not aware, was not aware of the possibility that a deposit of the deeds by Mr. and Mrs. Sharman without execution of a memorandum signed by them might be legally ineffective. To his knowledge, Mr. Dean did not intend to and did not instruct a solicitor to act on his behalf in the loan transaction. The borrowers defaulted and were without any funds to repay. Mr. and Mrs. Sharman demanded and obtained without making any payment the return of the deeds on the ground that no valid charge had been granted. Mr. Dean sought to recover his loss from A&W. Mr. Dean contended that A&W owed to Mr. Dean in respect of the provision of effective security a duty of care in contract or alternatively in tort. Mr. Dean's primary case was that he had impliedly retained A&W to act as solicitors in respect of each of the 4 loans, and accordingly A&W owed to him a contractual duty of care. Alternatively, Mr. Dean argued that Mr. Dolan owed to him a duty of care not to make a misrepresentation as to the efficacy of the security, and also care arising from the assumption of responsibility for putting in place an effective security. Mr. Dolan was in breach of both these duties. It was held that there was no contractual duty arising, but in the Court of Appeal it was held that a duty of care in tort was owed.
Do we see why they said so in item 6 in the summary in the head note?
Lord, I was just going to go, if I can invite you to read paragraph 5 and 6 of the summary in the head note. So 5, where to the knowledge of both parties a solicitor was retained by one party and there was a conflict of interest between the client and the other party to a transaction, the court should be slow to find that the solicitor had assumed a duty of care to the other party to the transaction, for such an assumption was ordinarily improbable. 6, the law could and should impose a duty of care on A&W towards Mr. Dean in respect of the provision of an effective security, the benefit which, to his knowledge, the borrowers wished to confer on Mr. Dean and which was fundamental to the loan transactions. There was the necessary foreseeability of damage and the necessary relationship of proximity for the law to impose such a duty of care, and it was fair, just, and reasonable that such a duty should be imposed. So if I can just seek to emphasise in my submission what are the analogous factors. Negligence was in failure to provide adequate security. The claimant had no legal representation of their own in the transaction, and the defendant knew that that was the case, and that is true of our case as well. But to come back to the point which was under discussion earlier, in the broadest sense, as is acknowledged by the Court of Appeal here, there was a conflict of interest between the principals, borrower and the lender. But crucially, when it came to implementation of the transaction, there was a common interest on the very matter which gave rise to the negligence, namely the effectiveness of the security. And we say that in our case, the common interest was clear, as I've described it earlier, in our case.
I've just been looking at paragraph 69, where Lord Justice Robert Walker explains why he is agreeing with Mr. Justice Lightman. And you've probably got that on 705.
Yes, Lord.
He says it's fair, just, and reasonable to hold that a duty of care was owed. And as Mr. Dolan knew or should have known, Mr. Dean was relying on him. So Lord Justice Robert Walker puts reliance as his number one reason.
Yes, my Lord.
And Mr. Justice Lightman, I think, relied on White and Jones, namely that the client of the solicitor was instructing the solicitor to confer a benefit on the lender. The two elements that he relied on, two cases he relied on, were White and Jones and Gorham and British Telecom. That's at paragraphs leading up to paragraph 40, while, as Lord Wilson has said, Lord Justice Walker didn't rely on that, but instead found it in paragraph 69 on knowledge of reliance.
I wonder if I can, obviously acknowledging the sense of that, my Lord. Paragraph 40 was a paragraph in particular which I wanted to cite on this question of the common interest. This is at page 700,
yes,
and it's Justice Lightman. In my judgment, by parity of reasoning and in the analogous situation which arose in this case, the law can and should impose a like duty of care on A&W towards Mr. Dean in respect of the provision of an effective security, the benefit of which, to his knowledge, the borrowers wished to confer on Mr. Dean, and which was fundamental to the loan transactions. The benefit issue there arises in our case, albeit the mechanism of the benefit is different. What the first offender was trying to do or purported to be doing, was to protect the bank's interest by saying the whole loan's going to be repaid, I know how much that's going to cost, and give me the discharges. So that is albeit the mechanism is different, is entirely analogous to the situation where what was supposed to happen was that the solicitor did something for the benefit of the party on the other side.
Well, I wonder about that, because in the context of a conveyancing transaction, what the solicitor needed was the discharges to give clear title. He wasn't conferring a benefit on the lender. What he was doing what was representing, what a solicitor would be doing in this context is represent that the funds will be paid in return for those discharges. So it's a slightly different case from Dean, if Dean is correctly decided.
My Lord, what the solicitor in our case required for the transaction, if she hadn't been careless, wasn't a discharge. What she required was a deed of restriction, because all the client was doing at that stage was selling one of the units, and that was the one that had to be released from the security.
Yes.
The point I'm simply trying to make is that whilst the mechanism of benefit is different in the Dean case, the general principle is the same, that in sending the deed and in making the representation she did, she was purporting to be acting in the interests of both parties. You will get your loan fully repaid. Our client will then be able to sell his properties unencumbered by securities. And before we leave that entirely, Mr. Justice Lightman was also influenced by the fact that the loan, the benefit was fundamental to the loan transactions.
The security, yes.
Yes.
Yes. Yes.
I think, in addition to the brief passage from Lord Justice Walker, Lord Justice Sedley also deals with this at page 702. Yes, paragraph 49 in the second column of page 702. Lord Justice Sedley says, thus, the final question to be asked in the present case is whether, given the relationship which should come into being between Mr. Dean and Mr. Dolan, there is in all the circumstances of the case, including the implications of the law itself, anything unfair or unjust or unreasonable in holding the latter liable for the former's consequent losses. I do not accept Mr. Wetherell's submission that once a Headley-Burn situation is identified, the answer has to be in the claimant's favour. It should by now be evident that the pigeonholing of cases is not the right way for the law to develop, by which I mean not simply to grow in ambit, but to gain in coherence. What I do accept is that Mr. Dolan had knowingly undertaken to give effect to the common purpose of the borrower, his client and the lender, by securing repayment of the loan and the interest on it, and that in the circumstances fully described by Mr. Justice Lightman, this placed him in a relationship with Mr. Dean, into which it is fair, just and reasonable that the law should introduce a duty of care.
Yes, and again, he's referring to White and Jones and Gorham as his building blocks.
Lords, can I...
He treats as inflicting honourable wounds on the law.
Yeah. This is straight within what Lord Reid was saying in Headley-Burn. If you know somebody is relying on what you say, then you have the three options. You say nothing, you say something with a disclaimer, or you say something without a disclaimer, in which case you take the consequences.
That seems to me, Mr. Clancy, to be a convenient moment. How much longer do you think your submissions are going to take? You've already taken an hour and a half.
Well, I won't be more than half an hour at the most, lady. I can assure the court of that, and hopefully less. I'm looking well to the end.
Well, we'll look forward to hearing from you further at 2 o'clock. Court is now adjourned.